The Leader of the Opposition.
President, I rise as the Leader of the Opposition as we consider the Assisted Reproductive Technology and Surrogacy Bill of 2025. And to the extent that it's necessary, President, I indicated at the outset that I'm not the lead speaker for the opposition in respect to this matter. I also indicate for the record, President, that opposition members in respect to this matter have what is customarily referred to as a conscience vote in respect to this matter, and so no one should read into anything in terms of the sequence of speakers or indeed who is a lead speaker or otherwise. President, the bill that's presently before the House, or the decision to have this matter considered by the House this afternoon, is of course a matter entirely for the government. Members will be aware that the government elects the order of bills that the House will consider this week, and members will be familiar with today's business program, which indicates that there are some six bills that could be considered today, but the government has decided that this will be the priority for the Legislative Council. I reiterate, President, particularly for those outside of the chamber, that is a matter for the government of the day, and it is for them to decide whether this is to be the top priority or not. For what it is worth, and this is my personal opinion, President, the Assisted Reproductive Technology and Surrogacy Bill of 2025 is not objectively the single greatest priority of legislation before the House at the moment, and I hope that in the brief time that I have, I can give some indication as to why I've come to that conclusion. As I say, President, this is for our party, the Liberal Party, a conscience vote matter, and I'm conscious, President, that for the majority of members in this place, they will not have experienced yet a debate that is a conscience vote debate. And it's in that context, President, and also in my capacity as the longest-standing Liberal Member of Parliament in either House, that I've given some careful consideration as to what might be the contribution that I can usefully make to the House as members exercise their conscience vote. I understand that certainly the two major parties have made a decision that there will be a conscience vote for members in respect to this matter, and it's obviously for other parties to indicate what their position is in respect to this matter at some later point in time. But as in that context, President, I've come to the conclusion that there is probably three things that I feel that I can usefully contribute to the debate that begins in earnest this afternoon. The first thing is to make some remarks as to what has been the experience of the Legislative Council in these conscience vote debates. Now, I will make those comments, President, with due deference, of course, to the Honourable Kate Doust, who's away from the Chamber on Urgent Parliamentary Business, of whom no one has had more experience than her in respect to these matters, and so my context should be considered in that particular context. The second thing that I think, President, that I can usefully bring to this debate this afternoon is to retell to members, particularly those, the overwhelming majority of members who were not here in 2019, what actually happened 6 years ago in respect to the bill that might be described as the precursor to the bill that's before us here. And I do feel, for reasons which will become relatively obvious quickly, President, that, might I say humbly, that no one is in a better position to retell that story than myself. And thirdly, I feel that what I can bring to the debate this afternoon, President, is what might be described as legal considerations to this bill that's before us, which is some 214 pages in length, which by any measure is a large bill, 369 clauses, and spread across 17 parts. Now, most of my comments this afternoon, when we get to the legal considerations, President, will be in respect to the surrogacy portion of the bill, but it should be observed by members at the outset that this bill is doing much more than simply just dealing with surrogacy. That is one significant part for it, and members might ask the question rhetorically, why is it that all of these matters have been combined into a single bill and not split into separate matters? With those introductory remarks having been made, President, I begin with the first of the three areas that I'd like to cover this afternoon, and that is to retell what has been my observations in terms of the experience of the chamber in dealing with these conscience vote debates. And as I say, I note that approximately half of the chamber have never been involved in such a debate to date. And I had the opportunity earlier today, Acting President, to speak to some of my colleagues about that particular type of experience, and this will be more elaborate than that. The first observation I would make, President, in respect to these conscience vote debates that I've observed is that there have frequently been calls for these debates to be held respectfully. Almost without exception, when these debates have been instigated by the other place, it has been accompanied by a statement, usually by a senior political figure, calling for the debate to be respectful. My observation, President, is that too often that call for a respectful debate has not been adhered to, most notably by those who actually call for it. And I observe in passing, President, that has already been the case in respect to this matter, regrettably by a small minority of individuals in the other place. And it is ultimately a matter that is recorded in Hansard, and I would say to their particular shame. But nevertheless, I have observed consistently, President, that in these type of debates there is a call for respect, and yet the people who call for it typically are not the ones to adhere to that standard. I might say quickly then, President, that the experience in this chamber has been quite different. And pleasingly, I have noted that the overwhelming majority of members of the Legislative Council have engaged respectfully in respect to these type of debates. And it's often been the observation, President, by members after the debate has been concluded about how very different the atmosphere and how very different the engagement has been in respect to these type of debates compared to some of the robust nature in which we engage on other matters on a weekly basis. So, as I say, President, two quick observations. One is that there has been often a call for respectful debate by individuals who then have not adhered to that themselves. Secondly, that the overwhelming majority of MPs have engaged respectfully in debate. And the third thing that I've observed, President, is that these debates can often be emotional. And newer members probably need to brace for that in respect to how these debates can unfold. The fourth thing, President, is that members will find that there is far greater public and media interest in this type of debate than almost any other debate that members will be engaged in. And the fifth and final point, President, that I would observe is that these type of debates can be particularly mentally and physically fatiguing for members. And so my message at the outset of this debate this afternoon, President, to all members, irrespective of your political party, is to look after yourself, and in particular to remember that ultimately you can only control your own contribution and your own actions in respect to this debate, and not those of others, least of all those from the other place. So I move then, President, to the second area that I feel that I can make a useful contribution this afternoon, and that is to recount for members what happened in 2019. And I am mindful, President, that of the 37 honourable members of this place, only 10 of the 37 were members in 2019. And I acknowledge and welcome back the Honourable Tim Clifford in particular, who has returned to the chamber as one of those 10 members from the 40th Parliament. Now, President, if I try to, as I was yesterday, sum up, how do I sum up the 2019 experience, which I think most political observers would say was pretty unique. They might use a number of other descriptors for it, but it was certainly a unique experience in 2019. There are three things that I would summarise for members as to what happened in 2019. And the purpose of it, President, is to dispel any myths, legends, fabrications and the like that have emerged over the years in respect to what happened 6 years ago. Three things that I would say about the experience 2019, President. 22 hours, the Allen Report and the Standing Committee on Legislation. I elaborate as follows, President. The 22 hours is a reference to the length of the speech that I gave as the lead speaker for the opposition in respect to the 2019 bill. And for most members and most fair-minded observers, if that is all you hear, President, that a member spoke for 22 hours, you will reasonably come to the conclusion that that is extraordinary, that is some form of gigantic delay tactic, and you might even come to the conclusion, President, that that is disrespectful. If you don't know anything else, it's reasonable for a person to come to that conclusion, President. But here's what actually happened 6 years ago in respect to that debate. The bill came on, as it's coming on now, by the decision by the government of the day, President, in February 2019. And it began on a Thursday, President, and it enabled me as the lead speaker on that particular day, it was Thursday the 14th of February, to speak for 29 minutes. 29 minutes, no criticism there, President, just happened to be the sequence of events, and that's when it came on towards the end of the day, and I spoke for 29 minutes. It quickly became apparent, President, that I was in no mood for the government of the day to be what I described as hiding a taxpayer-funded report into surrogacy and reproductive technology. And what I have here in my possession, President, right, is a two-part report by Sonia Allen entitled The Review of the Western Australian Human Reproductive Technology Act of 1991 and the Surrogacy Act of 2008. Part 1. Part 2. Massive documents which Hansard won't have the benefit of properly recording into the record. This is what the 22 hours was all about, President. I began the debate in February 2019 calling for the government to release this review which cost taxpayers $225,000. And in short, members, because I've got limited time today and I'd like to get to some of my concerns in respect to this matter, I said to the government of the day, I'm not going to stop talking until such time as you release this taxpayer-funded report. Now, what then happened, President, is I can only suspect that at first instance the government perhaps thought that I was bluffing in respect to this matter. Well, after 8 hours and 40 minutes spent over the course of 3 days, the 14th of February, the 19th of February and the 21st of February, it obviously became apparent to the government that this was no bluff. Now then, President, relevantly, I draw to members' attention, and this is why I started my remarks earlier about the calls by some for respectful debate. The media reported on that, what was referred to as a filibuster, And there was an article on the 21st of February 2019 by WA Today, and it was entitled "WA MP's filibuster has already taken one day. Here's why he won't stop talking." If members want to read it at another stage, they can do so. But I draw to members' attention and President to your attention that this article says as follows, and I quote, "Health Minister Roger Cook said the government would not release the review at this stage because it was not yet ready to be released and was not related to the amendments currently before Parliament." The article goes on to say, Mr Cook said Mr Goran was just trying to frustrate the bill. He is simply bringing an ideological perspective to it, which is extreme, and doing everything he can to frustrate the process. He said, "I emphasise this is just about making us compliant with the Commonwealth Sex Discrimination Act." That was after about 8 hours of debate, President, and at that particular point in time in February, this document, this gigantic document, 2 volumes, which I have in my possession, was not tabled in the Legislative Council. Members will be aware that then we have times of recess, some weeks where we're not sitting. The entire month of March 2019, we had some sittings. That particular bill was not brought on for a single minute of debate. So it stood adjourned. At the end of that month, President, this report, which cost taxpayers $225,000 and which the Health Minister at the time said wasn't ready to be released and wasn't related to the amendments currently before the Parliament, was tabled. Now, President, it took about 3 seconds to open the index of that particular review report and note that, amongst other things, in Part 2 of the report, Chapter 3, Subchapter 3.4, it said Human Reproductive Technology and Surrogacy Legislation Amendment Bill 2018, starting at page 58, continuing on with findings at page 60 and 61. So, President, how can a fair-minded person conclude anything other that when the Health Minister said that the review was not ready to be released, and let's park that for a moment, but was not related to the amendments currently before the House, how can we conclude anything other than that was untrue? Plainly, objectively, this matter had something to do with the amendments before the House. So, President, in March the report was finally tabled. And then there was a call, members, by an independent member of Parliament or a member of the crossbench, and he said that he was now obviously suspicious, President, as to what had transpired after the government had said, no, we don't have the report, doesn't yet exist, it's not ready for review, it's got nothing to do with the matters before the House, and now suddenly it's been tabled and suddenly has got a lot to do with the matter before the House. The independent member, President, then said, well, I'd like a little bit of time to consider this report. Look at the size of it. Now, interestingly, President, by that stage of time, the government had had it for 2 months. And so the honourable member wanted a bit of time. The government said no further time will be provided. We'll be dealing with this matter now and then. So what then proceeded, President, was the continuation of my speech during the month of April for another 13 hours and 20 minutes. Long story short, literally a long story short, President, the outcome was a move from me as the lead speaker for the opposition in respect to this bill to move that the bill be referred to the Legislation Committee. Now, the record reflects, President, that that move by me was opposed by the government. The move was successful by 1 vote. So, President, what we have here in 2019 is a bill that started in February with me saying, I'm not going to stop talking until you release this taxpayer-funded report. They didn't do it until March, and then in April we had a member of the crossbench who said, I'd like a bit of time to consider this. Government said no. I moved for it to go to the Legislation Committee. That was successful by 1 solitary vote. Now, President, what happens after that? Well, after that, we have the Standing Committee on Legislation. The Standing Committee on Legislation, which was chaired by the Honourable Dr Sally Talbot, MLC, for the record, a member of the then government, and it tabled report number 40. You see, it had the job now, by 1 solitary vote, have to consider the bill that was before the House. And, President, now I don't have the time to go through for members all of what that particular committee came back and said, but I will draw to members' attention two findings. Findings 13 and 14. Finding 13 in this report, the report, President, for the record, is a significant report, some 117 odd pages. Finding 13. The advice provided to the committee is that the amendments proposed by the Human Reproductive Technology and Surrogacy Legislation Amendment Bill 2018 to Section 23(1)A of the Human Reproductive Technology Act 1991 would be inconsistent with Section 22 of the Sex Discrimination Act 1984, Commonwealth, because they would create discrimination against women not currently present. In other words, members, if we proceeded with the bill, it would create unlawful discrimination against women. And yet, what were the public comments by the Health Minister at the time? Mr Cook was on the record saying, "I emphasise this is just about making us compliant with the Commonwealth Sex Discrimination Act." Well, objectively, that was false. But apparently it was only about one particular individual seeking to frustrate the bill. Finding 14, if the Human Reproductive Technology and Surrogacy Legislation Amendment Bill 2018 is passed extending eligibility for surrogacy to single men and male couples for social reasons, this would likely result in unlawful discrimination against women as a result of the existing requirement for women to have medical reasons. This cannot be avoided other than by a fundamental change to the policy of the bill and to the existing policy of reproductive capability as the basis for the availability of in vitro fertilisation procedures. And so, President, after that report was tabled in June 2019, remember what I said at the outset today, President, it's entirely up to the government of the day to decide what bills the chamber considers. After that report was tabled in June 2019, the government never, ever brought the bill on for debate ever again. For the duration of the 40th Parliament, another 2 years, they could have brought it on at any time. It did not come up. Not because of an individual member. Let's keep in mind, President, my contribution had concluded at that stage. I was not able, under the standing orders, to say another word in respect to the second reading debate. The government did not bring it back on. I might note in passing, President, the government also never brought any such bill in the entirety of the 41st Parliament either. So, President, I retell that story of 2019. As I say, I humbly say to members that I don't think that there's another member who's better placed to be able to speak to what happened in 2019 in those particularly unique circumstances. But I tell the story, President, one, so that members, as they consider their conscience vote in this matter, might block out the noise that might emanate from the other place, who might suggest a different set of circumstances happened in 2019. And sometimes, President, I've noticed in passing that the media likes to report, incorrectly, that somehow the entire bill was stopped because of one member. Well, that's simply not true, President. A majority of the Legislative Council referred the bill to the Legislation Committee, and the Legislation Committee found that the bill was so fundamentally flawed that it was unable to proceed, and evidently by the government's own actions in never bringing the bill on for debate again, they had to concede that point. That's what happened in 2019, President. It may be incredibly inconvenient for some members in the other place, but that's what the record reflects. Now, President, I turn now, as I say, to the third area where I hope I can make a useful contribution this afternoon as members consider this bill and consider it on its merits, that they read the bill, that they consider the implications of the bill, and that they block out the noise from the other place where the suggestion might be that the bill before them is a flawless piece of art that ought not to be critiqued. And I try to make now, President, some legal considerations in respect to this matter. Now, I accept at the outset, President, that the legal considerations are not the only considerations to be taken into account in this bill. There will be ethical considerations, and I have no doubt that members will want to raise them. There may well be members with lived experience that they want to raise particular issues. But as a, shall I say, retired lawyer, now Member of Parliament, I feel like I can make some contribution this afternoon in terms of the legal considerations before us. And so I begin, President, by asking rhetorically, well, what exactly is it that we are being asked to do here? Now, I reiterate to members that what I said earlier, that the majority of my comments at this point are in respect to the surrogacy aspect of the bill, not for a moment to forget that there are many other elements of this bill, and if time allows, I'll hopefully get to some of those things. But with regard to the surrogacy elements of the bill, which is particularly Part 6 of the bill, President, what we're being asked to do here, I would describe as creating a statutory regime for an unenforceable contract. Now, I qualify that comment, President, by drawing to members' attention, those particularly interested, and encourage them to turn to Clause 110 of the bill. Now, Clause 110 of the bill reads as follows. Under the heading Limited Enforcement of Surrogacy Arrangement, it says a surrogacy arrangement is not enforceable except to the extent that the arrangement provides for an obligation to pay or reimburse surrogacy expenses. So, Acting President, members can see very plainly that this thing which is called a surrogacy arrangement is not enforceable. Now, the very reason it's called a surrogacy arrangement, not a surrogacy contract, is exactly for that reason, although it does provide for this very limited circumstance, this sort of one-way street in terms of how it can be enforced in respect to any surrogacy expenses. But that's what we're being asked to do, Acting President, is to sign off on a statutory regime for a largely unenforceable contract. Now, that's not to say that that's wrong, members, but it should make us pause and ask ourselves the questions, what could possibly go wrong with an unenforceable contract? So let's begin by considering who are the parties to this unenforceable contract. Well, first of all, you have these intended parents, or maybe an intended parent, singular. You'll have a surrogate mother, and of course there'll be another person that's affected by all of this, President, and that is the child, or indeed the children, because of course there could ultimately be multiple births who are the results of this particular arrangement. They are the parties to this unenforceable contract. And Acting President, it's worth then considering what would be a breach of this contract. After all, you have these intended parents who are contracting with this surrogate mother to say, we would like you to carry this child for us and then hand over parentage of that child to us. That's the purpose of the contract or the arrangement. Well, what would a breach look like, Acting President? Might it be the case that the intended parents might separate and no longer want to take delivery of the child? Would that be a breach of contract? How would that be dealt with in an unenforceable contract scenario? What if the intended parents separate and then fight or dispute over what might be described as the custody of the child who is the product of the arrangement? What would happen if the intended parent or parents die? What happens, Acting President, if the surrogate mother changes her mind? And Acting President, what happens if the intended parent is unhappy with the child that's the product of this arrangement? Now, these are serious considerations that need to be considered, Acting President, and that is why there are protections in the existing law. Let's be clear here, Acting President. surrogacy arrangements and a surrogacy law already exists in Western Australia. This is not introducing it for the first time, but there is a regime of protections in place in Western Australia at the moment. And members should ask themselves the question, what are those protections at the moment and what will be the protections once this bill passes? Are they the same? Are they stronger protections, or indeed are protections being removed? And how important is it for members in any scenario that there be informed consent? Say, a regular principle that's employed in any medical procedure, that there be informed consent. Might I be so bold, Acting President, to suggest to members that if we know what we are creating here is a regime, a statutory regime for an unenforceable contract, then perhaps the notion of informed consent needs to be elevated even higher than what it was before, so that people understand exactly what it is that they are getting into, and that we ensure that there is an absence of duress, undue influence and unconscionable conduct. So having raised some of those problems, Acting President, members might say, well, what is the solution? What is the solution to try and address some of these concerns, noting that we already have a regime of sorts in Western Australia? Well, how we deal with it at the present time, or how you might deal with it moving forward, Acting President, is to ensure that the law provides for oversight pre-pregnancy and oversight post-birth. If you're going to create an arrangement, an unenforceable contract between parties for the provision of a child, then the best way that you can mitigate and protect against those risks that I've outlined and the prospects of what might happen with breaches and the like is to ensure that there is rigorous oversight prior to pregnancy and that there's also a regime post-birth. Now, Acting President, how does the current law mitigate against this risk pre-pregnancy? Well, it does that in one substantial way, and that is through the independent oversight and approval of the RTC. The RTC, Acting President, is the Reproductive Technology Council. What does this bill that's before us, Acting President, do? This bill abolishes the Reproductive Technology Council. So that independent body that oversees and in actual fact at the moment approves surrogacy arrangements at the moment pre-pregnancy to ensure, to mitigate against problems, that body that does that at the moment will no longer exist if this bill passes unamended. Questions should be asked why. Now, there'll be members in this place who may be firmly supportive of the notion of surrogacy, and there'll be others who will be firmly opposed to the idea of surrogacy. But might it be the case, President, that everybody is in favour of ensuring that parties are not unnecessarily traumatised, that people are entering into these arrangements genuinely with informed consent, that all of the protections are there in place? Might it be the case that every member might want that to be the final result? Well, this particular protection is being abolished by this bill. Now, I've said it in other debates, President, before any lawmaker asks me to tear down the fence or the gate that's been put there as a protection, I'd like them to explain to me why the gate and the protection was there in the first place. And that's not a notion that originates from me, President. G.K. Chesterton said that many years ago. But it's important as lawmakers, the serious lawmaker will want to understand why has that fence or that gate been put in place before they agree to tear it down. And my question to members as they contemplate exercising their conscience vote this afternoon is, why was the Reproductive Technology Council put in the position in 2008 when the law for surrogacy was first put in place in Western Australia that we said, we want you to look into these matters, we want you to oversee it, and we want you to approve the surrogacy arrangement before pregnancy? Why was that done? Now, if members can answer that question and then indicate why it should be taken away, I'll be very interested in having that debate and that discussion. What concerns me, President, is when lawmakers decide to tear down a fundamental protection like that without being aware that it even exists in the first place or why it exists. Now, instead, what this bill does, Acting President, is it tears down the Reproductive Technology Council, it abolishes it, it will no longer be there pre-pregnancy. And let's keep in mind, President, that the best protection here is pre-pregnancy. It's all a bit hard after the event, President, because what do you do then? Now there is a child in place. So the best protection is pre-pregnancy. It's being torn away and instead it's replaced by this, and I encourage members to have a look at clause 108 of the bill, which I would describe as a checklist of 6 things that the bill says needs to happen. But it's left on the basis of, well, we hope for the best. So if I turn to 108, Acting President, it says, when is surrogacy arrangement valid? And it says it's valid if it's not for reward, if it includes the contents of an arrangement under section 109, if it's in writing, if it's signed by the surrogate and each intended parent, it's entered into after the surrogate and each intended parent received counselling from a qualified counsellor about the arrangement and social and psychological implications, and obtained independent legal advice in writing about the arrangement and its implications, and is entered into before the surrogate becomes pregnant. That's the checklist, Acting President. So, members, what happens if you don't tick all of the boxes on the checklist? Does anybody care? Does anybody check? Or do we just proceed anyway? For example, what happens, members, if the surrogate and each intended parent don't receive counselling? The bill says that we'd like you to do that. We hope you do it, but we're not going to have a Reproductive Technology Council there anymore to make sure that you've done it and to approve the arrangement once we've confirmed that you've done that. We're not going to do that anymore. We're just going to hope for the best. Might I offer to members that that should be a point of concern, irrespective of what you think about surrogacy? Secondly, Acting President, it has to be acknowledged that there is also a regime in place at the moment in the current law and under this bill as well for some form of oversight post-birth. But as I say, how do you protect against and mitigate against the issues post-birth once the child is already in existence? Well, ultimately you can't. But we still have to do something, and so the way in which this regime proposes to deal with that is as it is at the moment, which is through the family court. And so you have a family court judge who ultimately is responsible for deciding who is going to be the parent and make what is referred to as a parentage order. And it's in that context, Acting President, that I'd like to refer to members this comment by His Honour Chief Judge John Pascoe. And Chief Judge John Pascoe from the Family Court says, this is, I should say, in 2015, he says, and I quote from page 6 of his, where is this from? It's the inquiry into surrogacy at the federal level to the Standing Committee on Social Policy and Legal Affairs, their inquiry into surrogacy. And what he said in 2015 is, and I quote page 6, "It is almost impossible for the courts to determine that it is not in that child's best interest to remain with the commissioning parents, even if they have broken the law." That's what the Chief Judge says. So when we talk about this gatekeeper and this overseer post-birth, what he is effectively saying is that as the family court, once the child exists and they're with the commissioning parent, even if the commissioning parents have thumbed their nose at the law, in other words, that checklist that I referred to earlier, those protections that we as a chamber are saying are very important. We want to make sure that the surrogate mother has had counselling, that there's been independent legal advice and so forth, and that they've done that as well. Even if that doesn't happen, even if the law's broken, well, it's almost impossible for the courts to determine that it's not in the best interest of the child to stay with the commissioning parents. I raise that, Acting President, simply to reinforce the point that any sort of oversight post-birth is almost meaningless. It's not completely meaningless, but it's nowhere near as strong a protection as what might exist pre-pregnancy, which is why we have the Reproductive Technology Council in Western Australia, and serious questions need to be asked of those seeking to abolish the Reproductive Technology Council. Now, Acting President, what about some of the other protections that are in existence in the current law in Western Australia? I note, Acting President, that in section 17 of the current law, so the current law is the Surrogacy Act of 2008, section 17 sets out that in order to be eligible to be a surrogate mother, the woman must be at least 25 years of age and, unless a special exemption has been given, must have given birth to a live child. Now, I'm just going to, again, rhetorically ask the question, Acting President, and this is important for us as lawmakers because we're being asked to remove that. That's not the case in this bill. This bill says don't worry about 25 years of age, the new age is 18. Don't worry about whether you've given birth to a live child beforehand or not. We don't care about that anymore. It's no longer a requirement. And the serious lawmaker, irrespective of whether they are pro or opposed to surrogacy, will ask themselves the question, why did the lawmakers in 2008 decide 25 years was the right threshold? And why should it now be 18? And perhaps, might I suggest to members, even more so, why did the lawmakers in 2008 decide that it was important for a woman who would be eligible to be a surrogate mother to have first given birth to their own live child? Why was that the case? It's an important thing for us to think about. Now, having thought about it and why somebody might put that protection in place, then we consider whether we're going to take that protection away. Now, I make no bones about it, Acting President. I'm in the camp that says that makes a lot of sense to me. Why you might have a woman considering volunteering to be a surrogate mother first having had the experience of delivering their own child. That makes a lot of sense to me. As a male, with zero experience, obviously, it makes a lot of sense to me. And I'll be interested to hear what other members have to say about that particular point. The point here, members, is that that protection will no longer exist. Was considered important by the lawmakers in 2008. Is it considered to be an important point in 2025? I note also, Acting President, that currently under Direction 9 of the Surrogacy Directions of 2009, members will be aware that, amongst other things, this particular bill that's before us is looking to repeal a whole range of acts, the Artificial Conception Act of 1985, the Human Reproductive Technology Act of 1991, the Human Reproductive Technology Regulations of 1993, the Surrogacy Act of 2008, the Surrogacy Regulations of 2009, and to revoke the Human Reproductive Technology Directions of 2021 and the Surrogacy Directions of 2022. All of these things are being taken away, President. And so I note that the surrogacy directions, it was the case that Direction 9 surrogacy directions prohibited the recruiting of birth mothers. What does this bill do? This bill expressly allows for not just the recruiting but the advertising. So that's a fundamental shift, President, from a direction that's being revoked, which says you ought not to be out there recruiting surrogate mothers, to a regime that says not only can you recruit, but you can advertise to them. Is that what we want? Is that the right thing to do? Are there any implications for that? Legal, ethical, or otherwise? Now, this is, of course, in the context, Acting President, where the bill ostensibly says that it is prohibiting commercial surrogacy from taking place, and yet almost as with sleight of hand, is then allowing for the advertising of surrogate mothers. So is there anything else that we can learn, Acting President, from the family court experience? I mentioned briefly moments ago the submission from His Honour Chief Judge John Pascoe, and time doesn't allow me to fully ventilate all of the issues set out in that particular submission. But I do want to draw to members' attention a couple of small points here, starting at page 14 of his submission, where under the heading of government oversight, he says as follows: the surrogacy industry is ripe. Now remember who this is. This isn't the Leader of the Opposition making these comments. This is His Honour Chief Judge John Pascoe, Chief Judge of the Family Court. Remember who is one of the overseers in respect to these parentage orders is the Family Court. And he says the surrogacy industry is ripe for abuse and exploitation of vulnerable women and children. Governments have an obligation to protect fundamental rights and prevent human rights violations. It is government responsibility to protect the poor and vulnerable, especially women and children, in surrogacy arrangements pursuant to local welfare laws and international covenant obligations. There are currently inconsistent approaches across states and territories, all surrogacy matters. There is need for consistency and coherence in any regulation of surrogacy. I pause there, President, to note in passing that the Australian Law Reform Commission currently is doing exactly that. The Australian Law Reform Commission, as I understand it, has been commissioned by the federal government to look at all the surrogacy laws across the nation, to look how there might be some kind of uniformity. Chief Justice is saying there's currently inconsistent approaches across all of those jurisdictions. So one might ask the question, why are we doing this now and not before the Australian Law Reform Commission has concluded its work, which I understand is due to take place in the middle of next year. In addition, Acting President, the Chief Judge says this at page 15 under the heading Regulatory Requirements for Intending Parents, Healthcare Providers, Welfare Services and Other Service Providers. So this is his checklist. This is the person who sees the problems at the end. This is the person who's been given the job in the family court, have been making these kind of parentage orders and sees the implications after the fact. And what's the very first thing that he says in the checklist? Bullet point number 1, background checks of the commissioning parents needed. Background checks of the commissioning parents needed. I hope, Acting President, that some member can show me where in this, how many clauses are there? 369. 369 clauses. Where in the 369 clauses we achieve that particular first point of the checklist from the Chief Judge. Background checks on the commissioning parents needed. He goes on to say, checks of the surrogate mother may also be needed. Home checks or assessments of the family may be needed. Clinics must keep effective records of every child's genetic history and names of all involved parents. Records should be kept indefinitely rather than for only a certain period of time. Adequate medical care and legal protection if either surrogate mother or child suffers any physical, emotional, legal or financial harm. Regulations should also ensure that surrogate mothers are properly informed prior to entering the agreement and thus capable of giving fully informed consent. This will require legal advice of a neutral party. I pause there, President. Who's checking? Members, in this bill, who is checking to make sure that the independent advice that's provided to the surrogate mother is independent? Who checks that? Does anybody check, or are we hoping for the best? Now, at the moment in Western Australia, the Reproductive Technology Council is the gatekeeper in respect to these things to make sure that nobody is exploited and that there is no unnecessary harm as a result of it. Time marches on, President, and so I move to the next area that I would like to quickly address. Some legal considerations. What might be described as a true expert, a family court judge, what they have had to say in respect to this matter. And, President, Can I ask members during the course of this debate, which will take some time this afternoon, to consider the implications of report number 66 from the Standing Committee on Environment and Public Affairs, tabled in August of last year, entitled Broken Bonds, Fractured Lives, Report on the Inquiry into Past Forced Adoption in Western Australia. And in particular, it's a huge report, Acting President, but at page 155, there's a very pertinent finding that's been made by the committee. Finding 9, very simple. Separation was experienced as trauma by both mothers and infants. The question I would encourage members to think about in this debate now, Acting President, is that to the extent that we can distinguish between the two, if there has been a voluntary arrangement where a surrogate mother hands over the child to the intended parents, that's not a forced adoption for the mother. I'll leave it to others to discuss whether there might still be some trauma about having been separated from the child that they have birthed. But that's not a forced adoption. But every single one of these, Acting President, is a forced adoption for the child. Every single one of them. Now, in the ordinary course of events, Acting President, if a child is adopted because of some family tragedy that's taken place, some abandonment, then we want the child to be looked after by the next best available person. That's why we have an adoption process, that's why we have a fostering system in Western Australia. But that's not what's going on in this bill here, Acting President. What's going on in this bill here is the intentional creation of a child for the express purpose of having them, in effect, adopted to another person. So we are expressly creating the very trauma for the child that report number 66 on broken bonds, fractured lives spoke about. We're doing it on purpose. Now, in fairness, Acting President, that's not this bill that's doing this in isolation. That is actually already the case in respect to the existing law, but this is the opportunity for members to be thinking through all of those particular issues. And what about the rest of the bill, Acting President? I've got less than 7 minutes to go in respect to this contribution, and it's not my intention to seek an extension, at least of all given the circumstances that occurred last time. So I'll quickly make this point, Acting President, and refer members to Part 16 of the bill. Much of what I've said so far this afternoon is in respect to Part 6 on surrogacy. But have a look at Part 16, and in particular Clause 326. What is Clause 326 seeking to do? It allows for what's described as the removal of reproductive material after death. So, Acting President, what it allows for is for, without the consent of the deceased individual, it allows for a regime without their consent for reproductive material to be extracted from a person, from a deceased person, and used by others. That's what we're being asked to agree to. Members have been given a conscience vote, certainly from the two major parties. Does that exercise our conscience? Do we say that that's okay? Now, that's not a legal consideration. I'm asking an ethical question now, Acting President. Is it okay for another person to have access to your body, not just any old organ, I might add, not just any old organ in the organ donor sense, but material that can be used to create a child? Should that be allowed for without the express consent of the person? There is a pathway that's been allowed for here. I encourage members to familiarise themselves with Part 16 of the bill and in particular Clause 326. And it really, Acting President, goes to my point earlier about the conflation of all of these into this package of a bill. If members have a look at the Surrogacy Act of 2008, which is the current law in this state, I think from memory when I was looking at it last night, it's less than 50 pages. I think it might be 48 pages or something to that effect. This bill that's before us, which admittedly includes much more than surrogacy, is 214 pages. So it's important for members to ask the question why. Why are we conflating all of those different elements into one particular package? There may be members in here who say, look, actually, I agree with the surrogacy laws, but I'm not too sure about this business about allowing people to have, in the case of males, the sperm extracted from a dead male for the purpose of being able to have a child. Not too sure that I agree with that. Well, it's all combined in the same package. Why is it, President, that that is the case and that the bill hasn't been split? I would say, respectfully, Acting President, that is an unnecessary way of dealing with this particular law. Nothing would have stopped the government from segmenting those laws. We see them all the time, members. You see amendment bills before the House, you see different bills at the moment. I think there might be a couple of different bills dealing with mining and the like. Why do we conflate an arrangement with respect to assisted reproductive technology generally? Why do we conflate that with surrogacy? And why do we then add on to that amendments in respect to the Human Tissue Act and the extraction of reproductive material from deceased people? Why are all those things being dealt with in the same bill? The extraction of reproductive material from a deceased person really has nothing to do with people's legal, ethical, social considerations in respect to surrogacy, and yet it's all in the same bill. So I conclude, Acting President, by providing 9 reasons why I'll be voting against the second reading of the bill. Firstly, the bill unnecessarily amalgamates those suite of issues into a single bill. It was unnecessary for the government to do that. Government could split the bill, has chosen not to. Secondly, this bill, respectfully, Acting President, prematurely seeks to change the law in Western Australia ahead of the work of the Australian Law Reform Commission that's not due to report until the middle of next year. Why are we changing the law now when we know that there's an active review underway at a federal level? And it can't be, Acting President, might I say quickly in passing, because it's urgent. Because if it was so urgent, why is it the case, Acting President, that no bill was brought in during the entirety of the 41st Parliament, and why was nothing dealt with since 2019? Thirdly, Acting President, this bill ignores what I've just referred members to earlier. That's the Broken Bonds, Fractured Lives report number 66 and their findings there. And what it will do as a result of that, members, it will increase the number of children who will suffer from that particular trauma. It has to be the case. If there is an automatic trauma from a child being separated from their birth mother, well, this bill is increasing the number of occasions where that's going to happen. Fourthly, Acting President, this bill removes existing protections for surrogate mothers. The Reproductive Technology Council, why is it being abolished as a result of this bill? And the eligibility requirements, not the least of which is the requirement that a live childbirth have already occurred. Fifthly, this bill masquerades, Acting President, as a bill that bans commercial surrogacy, and yet, in the same breath, it facilitates an almost unlimited compensation scheme while saying that it bans commercial surrogacy. If the bill goes into Committee of the Whole, I hope to be able to expand further on that. Sixthly, Acting President, this bill continues to resist child protection screening, despite all we now know, after all of these years in respect to child protection and child abuse. This bill continues to resist the statutory requirements for screening. Seventh, Acting President, this bill removes, this is a great curiosity to me, this bill removes the existing law which has a 5-year maximum imprisonment for facilitating commercial surrogacy. Gone, not in this bill anymore. Eighth, this bill expressly allows for service providers. Now keep in mind, Acting President, these service providers profit from providing this service. It expressly allows them to advertise for surrogates, including people of the age of 18, and consider for a moment, members, that we now have 18-year-olds in high school. And ninth, Acting President, this bill allows for the posthumous collection of gametes, even in circumstances without the express consent of the person who is now deceased. And so I hope, Acting President, in the short time that I've had this afternoon, I've been able to provide a useful contribution to members about how these type of conscience vote debates have happened historically, the culture that's occurred as a result of that, what actually happened in 2019, Acting President, and some of the legal considerations that I hope that members give to the bill that's before the House.